public gathering in Gujarat has recently stoked a controversy where he has said that people are unhappy, and even former judges have said that the NJAC system should not have been set aside by the Supreme Court. The law minister has in fact said that the government should appoint judges because that was the process till 1993 before the verdict had come. And the pre-1993, it was the law ministry which had appointed judges, as the constitution says that it is the president, that is the law, with the advice of the Chief Justice of India, who should be appointing judges. We're speaking to Justice Chelameswar, who is a former judge of the Supreme Court and in fact was the lone dissenter in the 5-judge constitution bench of 2015, which had given the NJAC verdict, striking down the NJAC bill and saying that the primacy of the Supreme Court collegium as far as appointment of judges is to be maintained. Thank you very much for speaking to us, Justice Chelameswar. I'm very grateful for you giving us your time. So first of all, sir, how do you see the comments that have been made by the law minister? Because it is something that there are certain concerns that you had also raised in your dissenting opinion.
Yeah, I never said, see, I can't speak for the people of this country. I don't know whether any individual can speak for the because even a government who enjoys a majority, and it only represents the majority people. Not that everything said by the government or minister is the view of all those who voted for that government. These are all rhetorical statements.
Okay.
Now, question is, do we require a change or not? My views are on record. I was a lone dissenting judge, as you rightly pointed. My point is this. Now, one thing I must tell you, whatever the law minister is saying and his reasons, I may not agree with him totally. I make it very clear. But one thing is this, his statement that as per the constitution, only the president can appoint, it means the government only can appoint the judges. Is required to be examined a little critically. If you recollect the NJAC, that 99th amendment, which was the subject matter of NJAC judgment, the amendment provided once the NJAC makes a recommendation, it was obligatory on the president to accept the recommendation and make the appointment. So Parliament was willing to denude the president and, in other words, the government of that freedom to deviate from the recommendation. Now, on the other hand, if you go by the text, of course, as the law minister was saying, the president shall appoint, fair enough, but plain statement. But then it is subject to an interpretative process by the Supreme Court, and NJAC, the Supreme Court judge's case came, 1993 judgment. Now, of course, the other reason that judges are spending more time deliberating on the appointment process, of course, well, I don't know. I don't, at least after my retirement, I don't have that divine vision to look into what is happening in the collegium process. They are spending so much of time that they are not able to discharge their judicial function.
But, sir, you were also part of a collegium. So, as a senior judge of the Supreme Court, you were number 2 in the Supreme Court at the time of your retirement. You have been part of not just one, but more than one collegium. Under a Chief Justice. Do you agree with what the law minister is saying, that it is not the collegium that should be appointing persons, because the collegium, the judges, instead of concentrating on judicial work, are in fact distracted?
That is absolutely, that's not a statement which I can agree. That judges are not able to do judicial work because of the collegium meeting is something which I'll not be able to agree with it. Fair enough.
Okay.
Now, that the appointment process, in fact, I commented in my dissenting judgment that in either case, even prior to 1993, things were not very, very wonderful.
Okay.
There were questionable appointments and questionable procedures followed. Post 93 also, in fact, all this I said in my judgment, my dissenting judgment. In fact, you can
Sir, I have been reading the dissenting verdict that you had given. So if I may, in your judgment, you had made certain points that, first of all, being that to entirely eliminate the government from this decision-making process would violate democratic principles. And you had also said that transparency is vital for constitutional governance, that the proceedings of the collegium are opaque, and the assumption of primacy of the judiciary seems to be flawed. These were some of the points that you had made in your dissenting opinion, sir.
Yes.
The law minister at this point also seems to be saying something regarding the opaqueness and the fact that people are unhappy because the appointment process is opaque. But he has gone on a completely different direction, and he seems to be criticizing the judiciary over the entire process itself. So how do you see this?
Ma'am, if he is criticizing the judiciary, it's the concern of the sitting judges, not a retired judge.
Okay.
No, you should be asking this question to sitting judges, because at least the Supreme Court, the law declared by the Supreme Court, majority opinion NJAC, the mere presence of the law minister in the appointments committee itself is considered to be detrimental to the independence of the judiciary. Whether the law minister can now, I don't know whether he has said it or not, but since you are saying that the law minister can criticize the Supreme Court, whether would it amount to interfering with the independence of the judiciary or not is for the sitting judges to decide, let them decide.
Okay. No, my question, sir, was that after reading what the law minister has said and going by what your opinion was in the NJAC judgment, how do you see this entire debate?
One thing, Aneesha, I'll tell you something. I never said in the NJAC dissenting opinion, hand over the power of appointment to the government. The question before the court was limited, whether a constitutional amendment was valid or not. That constitutional amendment said, instead of the collegium deciding it, create a body with two more members other than the collegium, the first three judges, the law minister, and representatives of the civil society. Whether such a body could be constitutionally undertake this responsibility and whether such a amendment is constitutionally permissible or not was the only question. I said it's permissible. There's another mode of the parliament decided it, and I didn't see anything wrong about it. Even that amendment did not say hand over the power to the government. Today the law minister seems to be suggesting, from what you have forwarded to me, that statement, seems to be suggesting hand it over to the government. Well, of course, I don't think that would lead us anywhere.
Okay. So, sir, this is a question that has been under debate for several years now, while you were here in the Supreme Court, as well as more recently with the sort of dispute we saw coming out in the open in the collegium under Justice Lalit. So what exactly do you believe should be a sort of a way out? Because we've been discussing this for a very long time, that the demand for a secretarial system, the demand for sort of more data being created, all of that has been debated. In fact, a database was recently inaugurated by Justice Lalit at the Orissa University as well. How do you see the way out from this entire conspiracy, from this constant debate and criticism?
I can only read out one sentence from my judgment. There are 1208 last two sentences. Note, see, I said that there are two phases in the appointment process, prior to 93 judgment, post 93 judgments, and after taking note, I said, no doubt during both phases, the appointment process yielded mixed results on the index of both independence and efficiency. Some outstanding and some not so outstanding persona came to appointed in both phases. Allegations of serious unworthy appointments abound, but our system provides for no mechanism for audit or qualitative analysis. Thus, systemic deficit has pathological consequences. And I suppose I said, and I have no reason to change my view on this.
So you believe that there should be?
There is no audit at all.
Audit of what exactly, sir? That is my question.
The process. The role played by the collegium, the role played by the government in these matters. See, for example, how is it in some cases the appointment process gets delayed even after the clearance by the collegium for months together, the appointments do not come out. Then just give one example. There are various other things, because I can't go on a full-fledged lecture here. So therefore, some kind of an audit is required as to what is happening.
Okay. So thank you very much for speaking to us, Justice Chelameswar. You've been very kind to give us all this entire analysis and so much of your time. Justice Chelameswar, of course, repeating that there needs to be some sort of audit, some sort of analysis of how exactly appointments are being made and what is being done, not just by the collegium, but also by the government. However, the Justice Chelameswar, while speaking to us, has said that he does not agree with the law minister's comment that the appointment process should be in the hands of the government. A lot is being debated on this issue over the last few years. This seems to be yet another point of debate in the country. Thank you.
NJAC amendment itself NJAC amendment itself said it. The NJAC's recommendation is binding on the president. Then how can the law minister say it's against the spirit of the constitution? I don't understand that. If that is against the spirit of the constitution, why was that amendment brought?
All right. Thank you very much, Justice Chelameswar. We've just been speaking to Justice Chelameswar. This is Aneesha Mathur in New Delhi for India Today.